Good day, everyone. My name is Jessie, and I'll be presenting on the ancient legal maxim, which means whoever owns the land owns it up to the heavens and down to the depths. This maxim has long stood as a foundation of English land law, reflecting the three-dimensional nature of land ownership. But today, I'll be critically evaluate its contemporary relevance, focusing particularly on how the decision in Bacardo versus Star Energy 2010 shapes subterranean ownership. I will also examine how modern statutes and judicial precedents have redefined this old principle to fit the realities of aviations, infrastructures, and energy development. The maxim symbolizes the idea of the land ownership where it is three-dimensional, extending both upwards and downwards. According to Section 205, subsection 1, paragraph 9 of the Law of Property Act 1925, defines land to include buildings, mines, and minerals, confirming that ownership is not limited to the surface. One of the earlier cases, Bury versus Pop 1586, reflected this absolute view that the landowner controlled everything above and below their land. However, such a literal interpretation suited a simpler time when there were no aircraft or underground pipelines. Also, according to Chu 2017, in the Conveyancer and Property Lawyers, explains that the maxim once represented the total dominion during the feudal era, but now functions mainly as a symbolic concept adapted for modern infrastructures. Similarly, Ray and Gray 2020 note that the maxim remains important as conceptual unity of land ownership, though its practical reach has been sharply restricted by statutes and case law. Historically, land symbolized wealth, power, and social hierarchy, particularly under the feudal system. In the early common law, as in Bury versus Pop 1586, recognized a literal form of ownership where any interference with the land, its air, or subsoil was considered trespass. William Blackstone, 1766, in his commentaries of the Laws of England, confirmed this idea, describing property as extending to the heavens and to the center of earth. But later legal writers begins to question this absolute approach. According to Wolff 1946, in Marquette Law Review, it pointed out that such total control could not survive technological age, particularly with the rise of aviations. As society industrialized, ownership that once worked for farming and local trade became impractical. Ray and Gray 2020 also emphasized that the maxim's strengths lay in its symbolism rather than its literal reach. It expressed the unity of land but not infinite ownership. Modern courts and parliament have reinterpreted the up to the heavens part of the maxim to fit technological realities. The law now distinguishes between lower airspace, where the landowner has control, and upper airspace, which is open to public navigations. In Kelson versus Imperial Tobacco 1957, a signboard projecting only a few inches into the claimant's airspace was held to be trespass, even without damage. Similarly, in Anko Brewhouse versus Berkeley House 1987, a crane arm passing over private land was also trespass, showing that the lower airspace remains protected. However, Bernstein's of Lake versus Skyviews 1978 limited this principle, holding that aircraft taking photographs from a reasonable height did not commit to trespass. This distinction was confirmed by Section 76, subsection 1 of the Civil Aviation Act 1982, which states that lawful flights do not amount to trespass or nuisance. Besides that, according to Bicknell 2018 in Landlord and Tenant Review, explains that courts today balance the landowner's enjoyment with the public need for air navigations. She also notes that the ownership now extends only to the height reasonably required for the ordinary use of land, which could create a more justice and more fair outcome. Therefore, the phrase up to the heavens no longer applies literally, where ownership stops where public necessities begins. The other half of the maxim, down to the depths, has also evolved. The leading authority in Bacardo versus Star Energy 2010, as previously mentioned in the introductions, which is important for these presentations as well. In this case, the defendant drilled diagonally beneath the claimant's land, between 800 and 2,800 feet below the surface, to extract petroleum under license from the Crown. The Supreme Court held that trespass occurred because the defendant's drilling physically passed through Bacardo's subsoil. However, the court awarded only £1,000 in nominal damages, since the interference was deep underground and had no impact on the surface use. This established that ownership of the subsoil exists, but only to reasonable depth, where interference affects enjoyment of the surface. According to Howell 2002, in Northern Ireland Legal Quarterly, observed that Bacardo introduced a reasonable depth rule protecting private rights without obstructing national energy projects, which is good. Also, according to Clark 2002, in University of Strathclyde Law Review agreed, arguing that the subsurface ownership must adapt to technologies like oil and gas extractions. Absolute ownership is no longer feasible. Besides that, Parliament reinforced this reasoning, like under Section 2, Subsection 1 of the Petroleum Act 1998, where all petroleum is vested in the Crown. Also, under Section 43 of the Infrastructure Act 2015, allow licensed operators to drill below 300 meters without liability for trespass. These developments show a consistent trend. Subterranean ownership is limited by statute and practicality, not by medieval doctrine. When we bring both airspace and subsoil together, it becomes clear that the maxim is now largely symbolic, unlike the historically. The maxim still expresses the unity of ownership, but not infinite power anymore. The modern courts interpret it through the lens of reasonableness and public interest, while cases such as Bernstein vs. Skyviews and Bacardo vs. Star Energy perfectly demonstrates this balance, where ownership continues but only where it serves practical value. According to Chiu 2017, it highlights that these transformations as a move from absolute dominion to regulated enjoyment, reflecting society's shift towards collective benefit. Also, according to Bicknell 2018, similar views the maxim as a guiding principle for balancing private property with public infrastructure. The academic work of McGarry and Wade 2019 support this as well, describing modern ownership as relative rather than absolute. Statutes such as the Civil Aviation 1982, Petroleum Act 1998, and Infrastructure Act 2015, where I just mentioned previous slides, further show how Parliament ensures private property rights coexist with technological advancement. The overall trend, therefore, is one of the harmonizations where law protects the landowner interest only to the extent that they do not conflict with the public welfare. In that sense, the maxim continues to inspire property law, but in a symbolic and limited form, unlike previously, serving as a bridge between history and modern necessity. And that's all from me. Thank you.